Good morning. My name is Scott Schreiber, and I'll introduce the panel in a second. I'd like to introduce my co-panelists for this presentation on Delaware corporate litigation as corporate markets rebound, what you need to know about litigation risks. With me are my partners John Friedman, who has worked in this area for a number of years, litigating cases in Delaware and elsewhere involving breaches of fiduciary duty asserted by plaintiffs, as well as securities issues and accounting issues. And also with me is my partner, James Thomas, who also has been around this country litigating breach of fiduciary duty cases, securities cases, and accounting cases, and dealing with the SEC on such issues as well. And we are also very honored to have with us today Rich Rollo of Richards, Layton and Finger in Delaware. And as we all know, Rich is without a doubt one of the leading practitioners in this practice area in the country. And probably he and his firm have more experience than just about any other firm in this country in dealing with these issues and really being on the cutting edge of litigation and advice with respect to M&A fiduciary duties, and we work closely with them, and it is always an honor to do so. Thanks, Rich. Appreciate you joining us. What we want to cover today are a number of subjects that have been the focus of litigation lately in Delaware, and as we will discuss in other jurisdictions as well. First, we'll talk about Delaware corporate litigation trends and settlement trends. John will talk about those. We'll discuss issues with respect to settlement, namely the disclosure-only settlement, and what the courts in Delaware have been doing with plaintiffs' application for fees in those situations. We'll then talk about recent cases on fiduciary duty. First, in the M&A context, there are a couple of major decisions describing the director's fiduciary duties in the M&A context. We'll talk a little more broadly about some developments in the fiduciary duty with respect to Caremark claims and with respect to some other types of litigation that have come up where you've had a director suing to enforce a director's rights as a director of a company against other directors. We'll talk about the specific situation involving directors of companies with substantial foreign operations, and then we'll turn to some specific M&A tools that have been the subject of litigation, namely the don't ask, don't wait provisions that you've heard so much about and read about. And finally, we will talk about some of the current litigation involving say on pay in the proxy litigation, as well as issues surrounding multi-district litigation, where we have actions being brought not only in Delaware but in other jurisdictions, and how the courts are dealing with those and which actions will go first and will proceed. So with that, by way of introduction, let me turn it over to John Friedman, who will talk about trends in litigation.
Thanks, Scott. I just want to set the stage a little bit why we're here and why we're talking about these issues. And I'm going to just give, before we get into discussion of some of the case law and important trends, talk about statistics and what happens when these cases are filed, what the disposition, where these cases are filed, and what the disposition of these cases are. I'm going to quote some numbers, and all these are out of the relatively recent analysis done by our friends at Cornerstone Research, who put out their periodic survey, last periodic survey in February. So in 2012, looking at mergers and acquisitions where public companies are being acquired, for those public companies that had market cap above $100 million, 93% of those transactions were challenged in shareholder litigation. And if you look at even a bigger market cap, $500 million market cap, 96% of those transactions were challenged in shareholder litigation. Shareholder litigation is filed almost instantaneously. Cornerstone found that frequently the announcement of an investigation was announced within hours the merger announcement, and typically first complaints are filed within about 2 weeks. The average transaction is challenged by 5 lawsuits. That means you've got 5 different firms competing to be appointed counsel and 5 different plaintiffs competing to be appointed lead plaintiff. The litigation is increasingly multi-jurisdictional. Of the suits that were filed or the transactions that were filed involving Delaware incorporated corporations, about 2/3 involved suits in both Delaware and in other jurisdictions. I think you might get some sense as to why, from comments in the rest of the session, why plaintiffs and litigants might be trying to avoid Delaware litigation. About 20% of cases filed in 2012 involving Delaware courts were filed in Delaware only. What happens to these cases? So we'll talk a little bit. We'll talk a little bit about settlement trends. Of these cases, looking at the last 3 or 4 years, 60 to 70% of the cases filed in any given year have settled. The rest of the cases, between 5 and 10%, have been dismissed on preliminary motion, relatively low percentage. About 25 to 35% have been voluntarily dismissed, which can signify a bunch of things. One is that the plaintiffs have given up based on some preliminary ruling from the court, or they've decided to proceed in other fora or bringing other types of claims. Of the settlements, and the first substantive topic we're going to talk about is disclosure-only settlements, some recent case law. Of the settlements that have been reached, approximately 80% of settlements are disclosure-only settlements, meaning that what shareholders get is expanded supplemental disclosures and nothing else. No kick in stock price, no negotiation of appraisal parameters, no reductions in deal termination fees, just better, more disclosure.
And the question as to whether it's better disclosure is one we can certainly debate. It's clearly more disclosure, usually a little bit some more cash flow information, or some kind of more evaluative information, especially in the real estate context. So a little more language is thrown in, and then the proxy goes out in final form.
Fair enough. James, you were going to talk about.
But that's the question of whether the additional disclosure is meaningful disclosure is an issue that the Delaware chancellors and vice chancellors have taken up recently in a couple of cases. The concern, obviously, with disclosure-only settlements is, given that the shareholders aren't receiving any meaningful economic interest in the settlement, the merger price is not being adjusted. It's really an adjustment to the informational right with respect to the proxy. The concern that the Delaware court has is whether this is really a question of the first filed plaintiff's firm selling their claims to take a fee rather than benefiting the shareholders in any meaningful respect. Very recently, Chancellor Strine, in somewhat surprising but consistent with what we'll discuss later, sort of a trend toward concern over this notion of a race to the courthouse and first filing in the transatlantic case, rejected an agreed upon settlement. So it's a situation where the plaintiffs and defendants had agreed to a settlement, had agreed on a cap to the fees. Obviously, defendants, the typical entrance is to escape the litigation. Sort of these merger cases are really just a merger premium to get the deal done from the defendant's perspective often. And the plaintiffs are looking, the plaintiffs' counsel primarily are looking to take easy fees and will often seek an injunction to try to pressure the defendant corporation into settling under those circumstances. On the slide, there's some quick background about the transatlantic case. Transatlantic had agreed originally to a merger agreement with a company called Allied World. That merger received several lawsuits. The merger didn't close, and they subsequently agreed to a merger with Allegheny Corporation, which in turn spun off several additional lawsuits. Alleging the typical claims: breach of fiduciary duty for not obtaining enough premium for the shareholders, and inadequate proxy statements. The settlement agreement provided for some additional disclosure of the type that are typical in this circumstance, some additional information about the investment advisors, perhaps some additional information on various ratios that were considered in the course of the deal. Chancellor Strine held a hearing on the fairness of the settlement, was dissatisfied with what he was hearing as to whether there was really any benefit to the shareholder under the proposed disclosures, asked for supplemental briefing as to the materiality of the proposed disclosures, was dissatisfied with that, and had a subsequent hearing in which he held that the agreed additional disclosures had no meaningful information, and I think that he was doubly concerned, not only that there was a lack of meaningful information, but that in this circumstance there was a real question as to whether the plaintiffs were adequately representing the class. You had a plaintiff, there were two named plaintiffs, one of whom held 2 shares of stock in the corporation, yet felt it was important enough to bring a lawsuit to challenge the merger consideration. And then the second plaintiff could not recall, held more shares in the company, but could not recall whether or not he had voted in favor of the merger. So I think that the concern over a quickly filed lawsuit, there was no books and records request or any diligence done, in addition to plaintiffs that there was a real question as to whether they were real plaintiffs or just a shell for the plaintiffs' counsel. The chancellor threw out the settlement and basically invited the plaintiffs to dismiss the case as responsible counsel. They have subsequently filed a voluntary motion to dismiss the case that's pending, but that case should go away. The similar circumstance in a recent case over the Paytech shareholder litigation, where Vice Chancellor Glasscock had raised some questions about. Can we move the slide forward? Similarly raised questions about disclosure-only settlements. This is a situation where similar circumstance, disclosure-only settlement, company made additional disclosures pursuant to the agreed settlement. The parties agreed to a $500,000 cap on attorney fees. There it was interesting that the plaintiff's firm argued that in a circumstance where the parties had agreed to the plaintiff to the attorney's fees, that the court really had no basis to look into the substance of the fees and should merely grant the fees. The vice chancellor really took that on, said there was really no basis in Delaware law to do that. They had not agreed on a fee; they had agreed on a cap on fees, so fees up to $500,000. And so the plaintiff sought to argue that there was a contract that had been formed for $500,000 in fees. The vice chancellor rejected that, applied the typical factors to a fee award under Delaware law, the time and the effort put in by the plaintiff's counsel, the complexity of the case, the contingency nature, and the like. What's interesting about the decision is the vice chancellor awarded $500,000 in fees. But that award was based on a single disclosure. There had been a litany of additional disclosures made that had to do with the process for selecting financial advisors, discussions of additional parties. There had been disclosure that there were more parties that had been considered. There was some additional disclosure about that. Some additional disclosure about the advisor's valuation of net losses that may have a tax effect over time. And then there was a disclosure about a potential conflict with the advisors. And that potential conflict with the advisors was the only one of the additional disclosures that the vice chancellor gave any credence to. It was a situation where Windstream, which was the acquiring company's advisors, a few months before, its advisors, Stevens, had advised Paytech on confidential matters, had access to the confidential information for the company, and at least three of the advisors that advised Windstream had been involved in the Paytech engagement. And the chancellor found that to be a meaningful piece of information that shareholders may have factored into their consideration of Windstream's offer, and based on similar disclosures in the past, provided the $500,000. But he was very clear that the other types of rote disclosures that have been typical in these types of disclosure-only settlements were not material, not meaningful, not worth attorney's fees. And in that circumstance, I think between Paytech, the holding corporation case, and Chancellor Strine's real broadside in transatlantic begins to raise some questions about the efficacy of the disclosure-only settlement in the typical M&A settlement.
Rich, you want to add on?
Yeah, and let me just try and put this in a little bit of practical context from the settlements that we see on disclosure only. As I've heard Vice Chancellor Laster or Chancellor Strine describe it, a typical disclosure-only settlement is ballpark $500,000, $450,000. That's your starting point. And then you adjust either up or down depending on whether or not it's a meaningful disclosure. And I agree completely that lately you see a lot more downward adjustments. Now, in practical terms, if it's a couple $100,000, you can justify that settlement for avoided cost of litigation. It's going to cost you a lot more than that to fight the fight. If you add a substantive settlement component, a bump in deal price, obviously plaintiffs are going to say, I get a piece of that, therefore your fee is $1 million or higher. If you add a structural piece, like I'll drop the termination clause, for example, or I'll reduce it, or something along those lines, the court has to kind of quantify the value to that. But even a substantive change like that, if no bidder arises, you're still talking a fee typically that's going to be north of $1 million. So a lot of the dance, if you will, initially in the settlements and the disclosure only are, what do you put in the disclosures to reach a number that's palatable that people will accept? I think Strine last week may have recently reduced a fee where I think the parties had agreed not to oppose something in the $400,000 range, and he hit it to $100,000 range. So it's happening more and more, in part because I think, as John mentioned, 93% of the cases get sued now, and the only way to get rid of them quickly without incurring cost is some form of settlement where you get the release.
One interesting phenomenon that I've seen in that case, where you get multi-jurisdiction actions in an M&A context. You have an action in Delaware, and let's say you have an action in District Court in D.C. And we know, and we'll talk about some more, how Delaware wants to take the lead on those cases. But we have situations where once it becomes clear, once the plaintiffs get the initial discovery, informal, in Delaware, and they see there's no real case here, they see it's only going to be at best a disclosure-only settlement, that is, the entity acted absolutely appropriately, they're more than happy to let the non-Delaware case proceed, seek a stay of the Delaware case, so they don't have to deal with these fee issues. And to the extent they're going to seek a fee, they'll be seeking it in D.C., let's say, or Oregon, and more likely to get, what they ask for and less scrutiny. And they're also, quite frank, a little bit concerned that they got to save their powder for the big cases in front of the chancellor or deputy chancellor, where they want to have some credibility rather than chasing these cases, which everybody recognizes are really, the merger was a terrific merger. The stockholders, got a premium and the disclosure was fine, and trying to build upon a fee in those kinds of cases in Delaware and impact their credibility. So it's an interesting phenomena that they're only too happy, including the Delaware-based firms, to let other firms around the country take the lead, get their share of the fees. They'll take their little piece and stay out of Delaware once it's established that these cases really are just going to be disclosure-only cases.
And on that issue, one of the first hearings you typically have in Delaware is the scheduling conference with the judge, either Chancellor Strine or Vice Chancellor Laster, or not to say Glasscock or Noble or or Parsons doesn't do the same, but the judge typically will make it very clear as to whether or not he thinks there's something more than disclosure. And I can think of a recent case we're involved in at the initial hearing where there was competing litigation in New York and Delaware, and the judge made clear, don't go to New York and make a disclosure-only settlement because we're going to go forward in Delaware if you do that. And so I think the judges recognize that fact that there are certain cases, if you will, being steered to other jurisdictions to be resolved. But if there are cases that have more substantive merit from the initial assessment in the complaint, I think they're, I don't want to say more protectionist, but they are more willing to make it known that that's a case they want to decide on the merits.
I think of it in terms of, I think they're really trying to discipline the plaintiff's bar in terms of the types of cases and the process for bringing the cases. So.
Well, good luck with that. It's been going on for a long time, and discipline hasn't yet quite been successful. Let's turn now to a related topic, as we've talked about the settlements, but let's talk now about some of the allegations and some of the decisions dealing with the obligations of directors in connection with M&A, the current theories, and what the courts are saying about bad faith claims. So, Rich, you want to lead us through that discussion?
Sure. There are two recent cases, both of which are by Vice Chancellor Noble, that I'll say are interesting, and you have to read them together. In both cases, it's the BJ Holdings case and the Novell case, and let me take them in order. They were decided about 2 months apart. In both cases, they dealt with allegations that the board of directors engaged in bad faith by disparate treatment of bidders. They had a favored bidder, allegedly, and tilted the playing field toward them in a sales process. Since the facts are important to distinguish the two, I'm going to spend a little bit of time on Novell, and then we can turn to the BJ Holdings opinion. In Novell, there was a public process, and there were multiple bidders involved, but two bidders emerged, Attachmate, who ultimately purchased the company, and Party C. The board said, give us your best and final. Both parties submitted bids, and Party C was the higher bidder monetarily by about 6 cents. Notwithstanding that fact, the board went exclusive with Attachmate. Now, after making the decision to go exclusive with Attachmate, Novell found out that Microsoft was going to bid about $450 million to buy one of its patent portfolios, and that transaction may occur in connection with or around the same time as the deal was going to close. They informed Attachmate of that information, but not Party C. Party C came back and put in a topping bid that was unsolicited, that was materially higher than its earlier bid. Ultimately, Novell negotiated a deal exclusively with Attachmate, in which the deal was about $2.2 billion to buy the company as a whole, but it was contingent upon Novell receiving the $450 million in cash from the sales portfolio. And to facilitate that transaction, Novell permitted Attachmate to pool with other people to finance. They got to go out and have someone else help pay the cost. The plaintiffs came into Delaware and said, wait a minute, you tilted the playing field away from Party C. You didn't allow Party C to pool with anybody else and potentially bring a higher bid in. You didn't tell them that at closing they would get $450 million in cash, which might have led to a higher bid, because if they knew they didn't have to come up with that extra money. And those two facts, while perhaps explainable for why you did it, the complaint itself had no explanation. In fact, in the case, if I recall, there was an allegation by the plaintiffs that the court rejected. So there was a complaint, said, here's the reason why they did it. The court said, I don't buy that. But after rejecting it, there was a lack of any fact from which the court could understand why this happened. And so this was in a motion to dismiss, and Noble said, I can't explain why. There's not enough information floating around, so I can conceive of facts that this would be bad faith. And now the test for bad faith is functionally, and I'll paraphrase, a rational person wouldn't do it. You can't have a rational reason for why this decision was made. Now, that decision happens. He lets the motion to dismiss go forward. Denies the motion to dismiss. The case goes forward, and now you go to discovery, and the defendants get to put forward their explanation. I believe it may be on summary judgment, or they're considering whether or not summary judgment is appropriate. 3 months later, you have BJ Wholesales. BJ Wholesales was another public process. They are in a much more consolidated business. BJ's and Costco, and I think there are maybe 3 or 4 others that fit that market. During the process, the board received an indication of interest from one of their strategic competitors. I think they say Party A. When they got the bid, the board looked at it and said, one, this party has no historic practice of acquisitions in the United States, so we don't know if this is a serious bid. And also, they're a competitor in a very small business. They talked to regulatory counsel and decided it wasn't really a serious bid. And so that was at the outset of the process, and they refused to give that bidder the confidential offering memorandum. And instead of engaging with strategics, they sent it to 23, I think, equity finance players. Process goes forward. Party A comes back and says, we'd really like to buy you. Here's a letter that's an indication of interest. Please consider us. Board considered it again, talked to counsel, and decided that it wasn't the right thing to do. Noble ultimately, there was a second bidder, a Party B, that offered some transaction that was a hybrid, but it was speculative as to value that was ultimately excluded as well. You get to the motion to dismiss, and the plaintiff said, you ignored bidder A and B. You did that in bad faith. Therefore, we should get to go forward. And Noble said this was a materially different case. In Novell, you had a serious bidder you knew was a higher bidder in 2 different cases, at 2 different stages of the process, yet you tilted it away from them. And because they were a serious bidder, that was the critical difference. In BJ's, you didn't think it was a serious bid. And from the facts available on the face of the complaint, I can conclude that there was a reasonable business justification for excluding them. Therefore, I'm going to dismiss the claims. And it hinged in part upon the facts that were available in the complaint and also publicly that you could rely on. One, you had a rational explanation, potentially, and one, you had a vacuum of information. And I think that's really the primary distinction between the two. I don't believe there are any other judges recently who've addressed the bad faith. But I think that's, if you look at Novell, I don't think it's a broad statement that the board could not treat bidders differently, and materially so, if they have a reason for doing so. It's just simply in the context and in a motion to dismiss stage, it may mean if you do that, either you need to make sufficient disclosures that when you get to the motion to dismiss, the court has something to look at, or be willing to get beyond the motion to dismiss and ultimately have to fight on the merits.
Yeah, as the court made clear in these decisions, the standard does it state a reasonably conceivable claim? And that's the buzzword. And at the motion to dismiss stage, you need far less to get there than you would once you get into discovery. So when you have facts being alleged, you do run the risk of finding that reasonably conceivable claim standard, because the standard remains in both of them whether the actions are, and then I quote, so far beyond the bounds of reasonable judgment that it seems essentially inexplicable on any ground other than bad faith, which Rich paraphrased. So that still is a very high standard for a plaintiff to have to meet.
And on that standard, the reasonable conceivability standard, for any of the litigators out there, that's the old motion to dismiss standard. And then you had a Supreme Court case that I'll say raised the bar a little bit. There's some Delaware cases that tried to apply the new Supreme Court standard, particularly Strine. It went up on appeal to the Delaware Supreme Court and said, until we tell you that's the standard, it's not the standard, remanded it back down. So there is some uncertainty with respect to, is it reasonable conceivability, which is here for anybody on the phone, it's a lower bar, or the newer standard that's a little higher. And at least until the Supreme Court tells us it's the higher standard, the court is operating under this, the older standard. And on that point, it's perhaps an interesting theoretical question. The reasonable conceivability, the theory that the judge looked at was not the theory articulated by the plaintiff. It was the judge sitting there saying, can I, i.e. the judge, conceive of a set of facts that might lead to an issue? Is that the right approach under that standard, or are you limited to what the plaintiff is arguing? And it at least appears at this point, based on BJ Holdings, the judge is willing to look beyond what the other side has pled as the theory to say, is there any set of circumstances based on these facts that might lead to liability? So I think it's helpful to the plaintiffs in terms of they may get beyond the motion to dismiss, whereas if you applied the newer Supreme Court standard, you might not get beyond the motion to dismiss stage.
And it also reflects one of the reasons why Delaware is reaching out, as we'll talk about, to be the primary jurisdiction, because the chancellors or vice chancellors will jump in and look beyond the immediate claims, try to understand the totality of what happened with respect to the merger transaction, and see, based on their experience, is there really something here that causes me concern as a judge? And even if the plaintiffs quite haven't identified it, or pled it even, they'll still look for it, and if they find it, they will, have the case, proceed. Not unlike what we find early on in a lot of cases up here in the Southern District, where in that first conference, the judge will, dig in a little bit to the facts, and even if it's not quite pled, if somehow something resonates with that judge, the case will be allowed to really proceed and take on a life of its own in a different direction. So that kind of activism and experience, does lead, to some of these results. I'd like now to jump just a little bit in dealing with the fiduciary claims in the M&A, to expand it a little more broadly as to some recent cases and talk about the Fuqua case, because that's developed some theories in fiduciary duty litigation, as well as in derivative litigation, that expresses some, more current views as to theories that we've dealt with, for some time. In that case, the court had to deal with the situation of a derivative demand being excused or being refused, and I'll go through the facts as to why it's kind of halfway in between the two of them. And also, whether there are any allegations that can sustain a Caremark claim. And the Caremark claim we'll talk about with respect to a director's oversight responsibilities. And the court also talked a little bit about the McWane doctrine of when they're going to stay a Delaware action pending litigation in another jurisdiction. In the Fuqua case, you had a situation, and again, the facts are somewhat unique, and they're somewhat on the extreme, and it's these extreme cases that let the bench sort of give these broad pronouncements, and they can do so in a case that obviously, given the extreme situation, it's hard to dispute with the conclusion. But then when you try to extrapolate to a less extreme situation, sometimes the analysis does not necessarily hold. In Fuqua, the demand was made on July 19th, 2010. The demand was basically that, remedy a breach of fiduciary duties, correct internal control violations, and if you don't respond in a reasonable time frame, we're going to bring a derivative action. There you had some accounting issues, potential restatement, and the litigation demand followed to take make an investigation. There was no written response given, but a special committee was appointed. All that happened to they announced it publicly, and plaintiff's counsel was told that there was going to be a special committee, and that some experts were retained. After that initial act, other than a preliminary meeting with the counsel they hired, nothing was done for the next 2 years. Nothing was publicly disclosed. As far as the record reflects, no investigation was undertaken. The committee did not meet. The allegation then in the case, when suit was brought in June 2012, so 2 years almost after the demand, that basically no investigation was conducted and the litigation should be allowed to proceed. Well, the court, in its opinion, ruled that when the board fails to accede to a plaintiff's demand, the plaintiff must plead with particularity why the failure is wrongful or not in compliance with fiduciary duties. And you have to raise a reasonable doubt that the board's action was consistent with those duties. Now, this was a situation where the board never formally responds. So you didn't have a decision from the board saying, we're going to take it over, and the litigation, or you didn't have a decision saying the litigation is meritless. So you're kind of in is this a duty, a case based upon a refusal? Is there lack of action for 2 years a refusal? Or is there lack of action really justification for an excuse under the standard law as to why you are excused to have to make a demand? And the court, kind of talks about it more generally by just saying, I think they acted in bad faith. It really, I'm not going to say it's futility because of it. I'm not going to say it's refused because they never took formal action. But it says really, have they acted in bad faith since the demand was made? And the court said they did not act in bad faith. The court went through a number of additional factors. You had, as it turned out, there was a 2-person special committee. One person became the CEO, so he could no longer be on the special committee. The second person on the special committee resigned. So you had no special committee. It sort of fell to the audit committee. But when the audit committee sought to retain experts, accountants, and lawyers to help it, the company refused to pay those experts. And you also had a situation where, in protest, other directors did resign. So when you put all that together, again, the facts are quite unique, somewhat extreme, needless to say. The court had little difficulty in saying that's just not acting with good faith, and because it's not acting with good faith, we're going to let it go forward. There is some guidance. We've seen situations where a demand will be made, and the company's response will be to move very slowly, and plaintiffs will then come in after a year or two and say, what gives here? We've waited. The fact that they haven't taken action in 2 years, that does mean it really is a demand refused case, and let it proceed because they haven't given a reason and the like. So this does throw some light on it, but again, it's extreme circumstances as to what constitutes bad faith in this situation. The second aspect of this situation that is, significant relates to the CAMARC standard. Now, by way of background, the CAMARC standard was set forth in a case going back to '96, and the standard is phrased is if the board actions consciously and in bad faith failed to implement any reporting or accounting system of control. It's recognized as the really most difficult theory in corporation law upon which a plaintiff might hope to win a judgment, because the Supreme Court made it clear in the Stone v. Ritter case that it really means a sustained or systematic failure of the board to exercise oversight. It's when you get into a situation, the complaint is based not on the board having taken a specific action where you have a board vote and consideration, and you might have duty of loyalty violations, or it's such an unusual situation, someone alleges bad faith, but where there is no system of internal control, no process at the board to manage and monitor really what the officers are doing. It became a little more current when we had a lot of litigation involving the options backdating, because those were cases where you didn't have decisions made. It was a process of awarding options that the board authorized, and that would go forward. And the allegations in those cases were, well, was the board really ignoring its responsibilities to monitor? So it's a very hard standard, and you found very few cases that have really proceeded past motions to dismiss or summary judgment on the Camark standard. Well, this case got beyond the motion to dismiss, and we have some guidance. The court in this case, part of the problem was, again, with the timing, in that you had, once the restatement was announced, and once the company itself said, we have internal control problems, we're going to have a restatement. After that fact, you had a payment of $150 million being made from the U.S. to entities in China, and the company couldn't exactly say who those entities were, or whether those entities legitimately received that $150 million, but the company said, but don't worry, we'll get it all back, not a problem, without any specificity. So you had a situation, as the court found, of the board sort of being on notice through the public announcements, internal control problems, and you had still financial actions being taken that were on its face inexplicable. So the court viewed that not merely as making lousy decisions or just closing your eyes to something, but really lacking an entire capability to monitor the actions of the officers, and really was they said, a conscious failure to monitor, and the directors basically disabled themselves from being informed and let the case go forward. So this is putting some life into Camark. We see Camark being asserted all the time. When you're representing a special committee of a board in a litigation demand, invariably one of the analyses one has to go through as part of the investigation is there a Camark claim here? Is there this failure to monitor, or are there policies, are there structures in place to permit the monitoring? The final interesting component of this litigation relates to what's the McWane doctrine and the stay of litigation. Whether the first filed case will be the one to proceed, and under issues of comity, Delaware will stay its action until the other actions go forward in other jurisdictions. Here you did have a first filed case in New York, but the New York cases had been stayed both in federal and state court pending the restatement, and that hadn't happened, so nothing was going forward. And the court was concerned that since some of the directed defendants were Chinese, they could not be served in New York, but as directors, they could be served in Delaware. So the court felt that only Delaware could do, and I quote, prompt and complete justice under the circumstances. The Delaware action would proceed, even though under the more traditional standards, Delaware should hold off pending the other actions. So Fuki, it's a very interesting discussion on a lot of these points, which have been debated much in the bar and in other decisions, and it's the most recent pronouncement on some of these claims that we see in almost every case. So it provides excellent guidance. There are also other developments involving the brief fiduciary duties of directors, and one of them relates to poison puts and the Sandridge Energy decision.
And I'll talk about that briefly. So, by way of background, what's referred to a poison put is a provision in a debt covenant that allows creditor, lender to accelerate loan repayment requirements if there's a change in control, typically a hostile change of control of a company. And earlier this year, Chancellor Strine issued a decision criticizing the invocation of a poison put in proxy materials. The background of this case, you've got a company called Sandridge, which is an oil and gas extraction company, which is having a proxy fight with significant shareholder, a hedge fund that owns 7% of its shares. Hedge fund doesn't like the way the company's been managed. They propose an alternative slate of directors, propose some other measures to allow a take over the board, issue their proxy consents. The incumbent board doesn't like this for whatever reason. They issue proxy revocation materials saying their proposed slate, the challenging proposed slate, is not as qualified as the current board to run this business. They lack sufficient experience in the energy industry. We're in the energy industry. And moreover, if there's a change of control, because we don't think that these guys are qualified, it's going to trigger our poison puts. The lenders are going to demand that we rebuy $4 billion of debt. And you know what, guys? We don't have the liquidity to do that. So read between the lines. So getting these proxy materials, a shareholder, not the hedge fund, but an individual shareholder, filed a suit saying this isn't fair. We are not being given the full opportunity to assess who ought to be running the company, throwing out the idea that the company is going to become, have this huge amount of callable debt, is coercing shareholders' assessment of the merits of who really ought to be running the company. So Chancellor Strine, in a decision on a motion for preliminary injunction, entered an injunction against the incumbent board from saying certain things in its opposition to the proposed proxy challenge. Two sort of critical things about the ruling. One is that Chancellor Strine actually looked at the qualifications of the proposed slate of directors, saw that according to the proxy consent, the proposed slate included former executives of British Petroleum, El Paso, former stock energy analyst, and concluded that essentially the opposition, the incumbent board's opposition to the slate was, we think we can do a better job than they can. We know more about oil extraction in Kansas, and none of these guys have actually worked in Kansas. And looking at that argument, Judge Strine concluded that there was not a reasonable basis to oppose a slate. Then looking at the second part of the question, what about the notion that the debt was going to become callable? Judge Strine, after looking at it, said the only reason why this would be callable is if this is a hostile takeover. If you're telling the shareholders and the world that the proposed slate is not competent and they're not qualified, and therefore this is a hostile takeover. Debt is not actually callable if you guys acknowledge that they do have the credentials and can probably confidently run the company. Judge Strine cited some evidence in the record that, in fact, many of the lenders would have been perfectly willing to extend their loans to the new board. Citing those two factors, entered a preliminary injunction putting severe constraints on the ability of the incumbent board to oppose the proxy. Shortly after that, the parties, the hedge fund and the company settled and seated several of the new directors on the board.
And just one comment on that, in terms of the fiduciary duties of the directors. As John mentioned, that it didn't become an issue unless the board took the position that the slate was not acceptable. And from a fiduciary duty analysis, the directors said, oh, it's not acceptable, therefore creating the resulting effect under the debt covenants, which is essentially an entrenchment maneuver. And the judge pointed out that there are very, very few instances when you can say this board is unacceptable, like you can't allow it to go to a known looter. And I think his standard was if it determines the members of the slate, quote, pose such a material threat of harm to the company or its creditors, it would breach their duty to allow the company to pass control to them. And he just didn't buy the argument.
Right.
And said it didn't even come close to that standard.
Right. And looking just at the put issue, he also held that the incumbent board essentially had the power to neutralize the put by saying these guys meet the minimum standard.
Another recent interesting case dealing with in the M&A context, with the dissident shareholders is the case of Callisman v. Friedman, which dealt with a dissident shareholder who was a director who felt he was being freezed out of his director responsibilities and considering what the company was doing as part of its strategic alternatives. John's going to, James?
Well, I can talk about it.
John
That's
talk
fine.
about it.
So this is another situation where you've got a strategic investor in the company who's allowed to nominate directors, has a director on the board. The company has a proposed transaction that the strategic investor doesn't like, uses their director to do what they can to oppose, including having the dissident director, the director in opposition to the overall transaction, actually filing suit to try to get access to company books and records and raising a host of challenges to the overall transaction. In decision, the board opposes the request for access to documents, says a large part of these materials are privileged. We're not going to waive our privilege by giving you access to these materials because you are hostile to our efforts. In decision by Vice Chancellor Laster, he rules one that a director has standing to challenge the overall transaction, so the director actually had standing to challenge what was going on here. And two, a director has broad rights to access the books and records of the company, including privileged materials prior to the time when adversity is clear, meaning prior to the time when the lawsuit is actually filed. Rich, I don't know if you've got more.
This is one I can't comment on because one of my partners was deposed in the case and we're actively involved. So I'll refrain.
I think that gives people the flavor.
I think, yeah, it's an interesting twist. You do find situations where given the director's other stock ownerships or involvement, you have concerns, legitimate concerns as to how much information that individual should have access to, and yet that individual does have the right and his own fiduciary or her own fiduciary obligation to participate. So it's very carefully done and structured to provide some information, but also to protect the shareholders by not providing all information. The decision is very instructive with respect to those issues. Finally, before we move on, there is one other fiduciary duty case that's received a lot of publicity, and again, it's a case with very unusual facts, extreme facts. The Protocol decision with respect to fiduciary obligations of a director in a company that has significant foreign operations. I think Rich will kind of review that.
And Protocol, as was suggested, is somewhat of an extreme scenario. In a thumbnail, the chairman of Protocol is alleged to have stolen the company, which was primarily the subsidiary was based in China, went to the register for stock and transferred it to his name. Now that was done in Chinese, obviously. It was not noticed by the board for 2 years. It was not noticed by the auditor for 2 years. There was an online publication in I think it was Alpha One or something like that, online publication that noticed the fact that notwithstanding the SEC filings, which presupposed that the company was still owned by the parent, the United States, in fact, its primary asset had been transferred. Lawsuits filed. At the time, there were some independent directors. They resigned from the board after these allocations became known, but nevertheless moved to dismiss under 23.1's alleging that demand was futile. If a majority of the board is independent or disinterested, you could get a dismissal. But here they had resigned. That argument was not met well by Chancellor Strine, because essentially, had you allowed the dismissal to happen, the only director left is the chairman, who they say stole the company. And there was no one left to fight on behalf of the stockholders, which is your typical scenario where you have an independent board. The independents then can control the litigation. Chancellor Strine made some, I'll say, colorful remarks, and I'll distill them down. It was a transcript ruling, but there are a couple things he said that have to be read in the context of that backdrop, but I think have broader application if you are a director and the company, either the company you're on the board for or its significant subsidiaries are abroad. He made three big suggestions. The first is, in order to fulfill your duty of care as a director, you may have to actually speak the language. If anyone on the board spoke Chinese, perhaps they would have noticed in the 2-year period that it had been transferred. And I think he perceived, and I'm reading between the lines, I think the court perceived that one of the reasons that no one had noticed that a $200 or $250 million company had been transferred is nobody could read the language. So he suggested that it might be necessary for the director or at least someone on the board to have that language capability. Second, and it goes back to a point made earlier under Caremark, is you have to have adequate systems in place. And in the context of foreign companies, it will be measured in the context of where the company is. So you need advisors adept at navigating Chinese regulatory issues or the language skills. So what would be perhaps a acceptable oversight system in New York might be material different than Denmark or Beijing or someplace else, and I think that's somewhat of an obvious statement. In that context, though, he made the suggestion, I keep saying Chancellor Strine made the suggestion, that it might be a good idea to have to go and have directors visit the location of where the facilities are. Again, in his example, I think he used in the transcript was if on a piece of paper it says you have a warehouse in China and nobody walks by the warehouse to see if it in fact is a warehouse that's filled with your goods, that's a failure. If nobody is, even at a 30,000 foot level, walking, visiting the operations to determine whether or not they appear to be operating in the ordinary course. And the final point he made, which I think is also a very practical point, is proportionality. If you're a $1 million company, your oversight process is going to be materially different than a $10 billion company. And that all of these 3 points really go to context, both location, economics, and language issues along those lines.
Thanks, Rich. I'd like to turn now to some specific M&A related provisions and the court's reaction to them more recently. And one of them that has received a lot of litigation and discussion relates to the don't ask, don't wait provision. I think, Rich, you were going to discuss that for us?
Sure. This became, I'll say, the issue du jour during December of last year. In a very short period of time, you had 2 or 3 opinions in transcripts largely addressing this issue. And let me just put it in context. When you're engaged in a transaction and you're running the process, everybody enters into a confidentiality agreement, and oftentimes it'll contain a provision that says if you're part of the process, you're part of the process, and you can't functionally go outside of the process and lob in a bid. The don't ask, don't waive provisions say that you are not permitted to ask us, either publicly or privately, to waive the standstill. Now, there are, in the slides, the next couple slides, there are a few opinions. The first is Rehab and Celera, where there are some initial transcripts suggesting that these might not be defensible. And I think most of the notoriety came when you hit to complete genomics. It's a transcript ruling by Vice Chancellor Laster that in words or substance, suggested that you were breaching your fiduciary duty by agreeing to this type of a provision. And let me tell you why. You were burying your head in the sand. If you told someone that, let's say there was a change in circumstances and party A, who's a bidder, might now be able to bid $50 million more, but they're not allowed to come and tell you, by the way, the facts have changed, I can now bid $50 million more. You as a director who have continuing obligations until the deal is done, were shielding yourself from accessing that information. And the logic that Vice Chancellor Laster, in pretty strong terms, applied is consistent with that argument. That was the argument. It was a transcript ruling, therefore not as carefully written out in the sense of citing case law and whatnot. That received a lot of press, and shortly thereafter you had an opinion by Chancellor Strine in Ancestry. I don't want to say who backed away from that position, but put that transcript ruling in context. He said, listen, that's a transcript ruling. That's not the ruling of the court. But let me tell you what we think. There may be a place for don't ask, don't waive provisions. If you use them, they are potent devices. You must have a board that understands them, understands their purpose, and is using them to achieve a goal. And the goal is the one stated at the outset, which is driving all of the bidders into one process and telling them, you must follow our process, and I can bring the gavel down and end the process, which at least theoretically would mean that the bidders put their best offers on the table, as opposed to having a little reserve, waiting till a deal is signed, and then, oh, well, I can top it by, the breakup fee plus a little bit, and continuing a process. So there is a place in the law, according to Chancellor Strine, and I think it's consistent with the other rulings, for this. But before you go down the path of using it, make sure that you're able to explain both at the board level and whoever's going to ultimately be deposed as to why this is employed, why it was used, how it was used, and that thought was put into it. I think it is fair to say that use of this type of a provision will receive I don't want to say heightened scrutiny, but will be fact-specific and will be looked at very carefully by the judges.
And this, interestingly, this is also one of the areas where we did get into this issue of which jurisdiction an action should proceed in, because there was a decision on don't ask, dealing, I think it was in Washington, by a state court judge, a first level state court judge, saying, maybe it's not so bad. So that got the Delaware courts a little bit, this is our provision and we've been interpreting it, and here you have other interpretations. You're going to find more forum shopping when it comes to, bringing litigation, and we'll turn to that. But it was an interesting development.
I think one of the key to this line of cases is the director understanding of the standstill, because in the first cases it wasn't clear that the directors even knew that there was a standstill or don't ask, don't waive that had been written into the agreements.
I think that's absolutely right. In an Ancestry, even where he said Chancellor Strine indicated there was a place for it, he nevertheless enjoined the transaction, because in that context, the directors of Ancestry couldn't really articulate why it was being used and didn't understand it. So
the advisors had been writing these into the deal agreements, but the directors had no concept that they were in the agreement or what it meant for purposes of the negotiation. And that's really where this turns on. That's why the scrutiny is going to be, do you as a director know that this provision exists, and have you been advised as to why, and made a business judgment that can in turn receive the presumption of due care under the circumstance.
And I think that's an important point, because I don't want to suggest that the advisors put them in, then come back to the special committee or the board and say, here's why we did it. I think the point James just made is an important point, which is before putting the provision in, it's a conversation by the board or the special committee or whoever is running the process at the board level, deciding affirmatively to use this type of a device as part of the process after receiving advice from the bankers and the lawyers and whatnot. Then that is the decision that you're going to get business judgment for. and that's how you ultimately could defend it to be used in the process. So it's making the involvement by the board beforehand, not after the fact.
One other trend in litigation, we're seeing a lot of litigation relates to the say-on-pay claims and annual proxy litigation that's been going on. And John will walk us through what's happening in that arena.
Yeah, just so a word on background. Say-on-pay is a requirement that comes out of Section 951 of the Dodd-Frank Act, which requires public companies to, at least every 3 years, have an advisory vote on their executive compensation. There have been a variety of rules propounded by the SEC saying what you need to, as a company, disclose in conjunction with your compensation practices. Like, you need to disclose the elements of your compensation, how your senior officers are compensated and what the elements of that compensation are, how those amounts are calculated, if the calculation is based on some form of formula, what that formula is. There have been two waves of this litigation. So when say-on-pay became effective 3 years ago, there was a wave of about 50 suits filed. Whenever companies had these votes and shareholders voted no, we vote no on the executive compensation. It's an advisory vote. It doesn't have any binding effect. But the plaintiffs' bar filed this series of lawsuits saying your shareholder said no. That shows that the directors breached their fiduciary duties in approving this executive compensation. The directors themselves or the officers themselves have been unjustly enriched. The shareholder said so. These suits didn't fare particularly well in the courts for a couple of reasons. Right? Large numbers of these suits were filed. Large numbers of these suits were dismissed outright. Many cases dismissed for demand futility, failure to make a demand on the board or explain why demand was going to be futile. Courts also dismissed a lot of these suits because the shareholder vote is an advisory vote. It's not binding on the company. And simply alleging that shareholder said no wasn't sufficient to adequately plead a claim. Number of these suits were also dismissed because courts held that executive compensation decisions are fundamentally business judgment decisions and have, under most state standards, highly deferential review of business judgments. So last fall, plaintiffs' lawyers being creative, there's a second wave of these suits. One note on sort of the background of the theory. Last spring, April 2012, a decision called Nee versus Brocade involving the IT company Brocade. Shareholders filed a suit regarding Brocade's proxy proposal to increase the number of shares available in its executive compensation plan on the grounds that it was dilutive, by increasing the amount of compensation available for executives under the plan, diluted the interests of other shareholders. They got a California state court judge, Judge Kleinberg, to enjoin the annual meeting, which gave the plaintiffs obviously a lot of leverage and were able to negotiate a fairly favorable settlement. A couple months after that, the plaintiffs took essentially the same theory and said, can we revive the say-on-pay idea? And starting late last summer through last fall, filed 2 to 3 dozen additional suits challenging the adequacy of proxy disclosures concerning executive compensation, saying that shareholders are not getting a meaningful vote on say or pay because the disclosure is inadequate. Why is it inadequate? Well, you can fill in the blank. You didn't tell us enough about why you hired your advisor. You failed to tell us enough about who you selected in your peer group. Your description of the factors that you considered is vague, and we don't understand it. You failed to tell us why some of your executives were treated differently than other executives. In addition to all these suits that were filed last year, since the beginning of the year, the plaintiffs' bar has announced 50 investigations, meaning that they are looking into adequacy of disclosures. So far this year, relatively few new suits filed, and we'll talk about why that is in a second when we talk about some of the decisions. So I'm going to talk about three decisions that cover basically the trend of what's going on, how courts are evaluating these claims. The first is EMEA Capital versus Apple, which is the prominent battle that Apple is having with its shareholder David Einhorn. This suit concerns two proposals that Apple has pending. Actually, the particular say-on-pay aspect doesn't actually involve Einhorn. It involves another shareholder who glommed on to the dispute. So Einhorn filed suit. Apple put together a package of proxy proposals. One proposal was a combined proposal of joint proposal of four different items. An item to facilitate majority voting for directors, an item to revoke the director's ability to issue blank check preferred stock, meaning unilateral discretion for the directors to approve preferred stock, a provision to establish nominal par value for the stock, and a provision to clean up miscellaneous provisions of their articles of incorporation, all combined together as one shareholder proposal. Einhorn and individual shareholder filed suit saying, we don't think under the SEC rules these can all be bundled together. We support some of these, we don't support other these. There's no reason we should get a yes or no vote. The court said, you know what, let's look at the SEC rule. You're right. You can't bundle the proposals together in this way. Issued a preliminary injunction essentially requiring Apple to resubmit its proxy materials. Now, the individual shareholder then filed a further claim that the say-and-pay provision in Apple's disclosure was not sufficient. Apple's say-on-pay provision on executive compensation was 16 pages, included a fair amount of detail about what the compensation consultant had recommended, who the company had selected as its peer groups, the factors that it relied on in setting executive compensation. And the judge, in sort of ruling in Judge Sullivan in the Southern District, ruling on this part of the case, said, you know what, I'm reading Apple's disclosure. It looks pretty much what the SK says you're required to disclose. Say-on-pay is not intended to impose any new disclosure requirements. I'm going to deny that part of the injunction. Second case I want to discuss is a case out of the Northern District of Illinois, which came down last month, involving AAR Corp. Similar kind of case where you've got AAR is a aviation products company. Shareholders challenged their disclosures. AAR's executive compensation disclosure in its proxy statement was about 40 pages. The specific complaints that the shareholders raised were, it wasn't clear from the disclosure how the board selected its compensation consultant. The board changed compensation consultants, and it wasn't clear why they did that. Wasn't clear why AAR picked its peer groups in setting comparables for executive compensation. And it wasn't clear how one particular pool of executive compensation had actually been allocated between the shareholders, and a couple of other issues. Judge St. Eve in the Northern District of Illinois last fall denied a preliminary injunction trying to enjoin the annual meeting, ruling in essence that say-on-pay is supposed to be an advisory vote. It's an advisory vote, so there can't be irreparable harm because all we would be doing is enjoining something that's advisory. this spring, in April, she dismissed the case on a motion to dismiss, ruling as similar to how Judge Sullivan ruled, that I'm going to look at the disclosure. I'm going to look at Regulation SK. The disclosure seems to meet what Regulation SK requires. Say on pay does not impose additional disclosure requirements. The third case I'm going to discuss is another case out of state court in California, the Gordon versus Simon Tech case, which is by the same judge who issued the Brocade case I mentioned earlier, Judge Kleinberg. Same result as the two others that I've discussed, a little bit different in terms of methodology, in that the judge actually went through and looked at the proposed disclosures and the insufficiencies of the disclosures and concluded, rather detailed decision, none of them were material, and dismissed the case. So I think looking at the trends, plaintiffs have not been doing particularly well on this theory. The pace, although there have been a lot of investigations announced, the pace of new cases actually been being filed has slowed dramatically since these decisions have started coming out.
Thanks, John. Finally, I'd like to turn back to the subject we've been, it's come up a couple of times, relating to the relationship between the Delaware litigation and litigation in other jurisdictions, primarily in the derivative context, but it also turns up in a direct shareholder context. We all know the background. We have Strine's paper that he gave saying Delaware, if a company has incorporated in Delaware and it's selected Delaware as the governing law, Delaware courts should interpret it. We need consistency. We have an article coming out by Vice Chancellor Parsons in the Washington and Lee Law Review dealing with the same subject, taking the same position. We know historically there have been a couple of cases that have received a lot of press, the Topps case and more recently the stock exchange. So you do have this tension as to which court, which law is going to apply, and it really came to a head in a case James will discuss recently, the Pyatt decision dealing with giving effect to a decision by an out-of-Delaware court.
Sure. There's actually it says two tracks that are bringing this issue to a decision. One is the Pyatt case dealing with allergen product, and the second is the Chevron and FedEx cases concerning the whether Delaware companies can adopt forum selection in their bylaws or their charter, and whether that's valid and whether the courts will uphold that. So to the extent the Delaware corporation can put a forum selection clause that a matter concerning its corporate governance must be brought in a Delaware court, that begins to strike at in a very broad way the ability of plaintiffs to bring cases in multiple jurisdictions, because the theory of that being that the bylaws is a contract with the shareholder, and by purchasing its shares, it's entered into a contract, and part of that contract is that if it's going to bring a lawsuit, it will be in Delaware. Chancellor Strine recently heard that case, and the transcript and indications from that suggest that he gives some credence to the ability of a Delaware corporation to validly put a forum selection clause into its bylaws or its charter. That makes sense, not to anticipate his ruling, but that is consistent with what he is, among others, put forth in the article Scott mentioned, that the presumption, at least argued in the article, is that the state of incorporation should be the forum state, absent some compelling circumstances, such as for judicial efficiency's sake, that the forum state case wasn't filed until sometimes later, so that the cases in the other jurisdictions have have progressed to such an extent that it doesn't make sense for judicial efficiency to for the forum states courts to handle it. So that's to be determined. Now, one the potential kink in that is this the Pyatt case, the allergen case. There was a splash back in the fall when the Chancery Court held that, and just by way of quick background, because I know we're starting to run up against the time limits, the allergen shareholder cases filed in multiple jurisdictions. Even though the Delaware case was filed first, the California case was decided first. And the California federal case, the judge determined that demand was not excused and dismissed the case with prejudice. The Delaware court it presented same facts and circumstances. It had stayed its case to allow a books and records examination to go. So whereas the California case was a circumstance first race to the courthouse, the Delaware case was a race to the courthouse, but then an intervener came in with books and records and took some time to review the underlying facts and circumstances before amending the complaint to a more fulsome complaint based on the facts and circumstances. The chancellor, vice chancellor, rejected the collateral estoppel effect of the California case and said that this is a question of the internal affairs of the corporation, that a shareholder isn't acting on, so that the theory of collateral estoppel in that circumstance is that a shareholder brings a case on behalf of the corporation in derivative context, and such that if demand is not excused, a subsequent shareholder who's also acting for the same nominal plaintiff, the corporation, is in privity and doesn't get a second bite at the apple under the traditional collateral estoppel circumstances. In the case back in the fall, the vice chancellor rejected that, said that's not the circumstance. It's a question of internal affairs. They're not in privity because under Delaware law, until you have survived the motion and been given the right to move on behalf of the corporation, you're just a shareholder asserting your own rights. And then secondarily, under the circumstance, held that there wasn't adequate representation in the California case. Recently, the Delaware Supreme Court rejected that argument, and sort of rather than the notion of the internal affairs doctrine that Delaware law should be presumptively applied, and really that Delaware should be the presumptive jurisdiction for this case concerning a Delaware corporation, the Supreme Court said no, traditional collateral estoppel applies, that the plaintiffs in California were on behalf of the company, the plaintiffs in Delaware on behalf of the company. That satisfies the traditional collateral estoppel rule, which is the rule of the jurisdiction in which the original decision was provided. You need to look to California law, not Delaware law, and just sort of applying a straight collateral estoppel traditional argument said that that the Delaware case was stopped. It had been decided, and so I say that there was a bit of a kink in the theory of that I think Chancellor Strine and the other vice chancellors have been developing in a series of decisions to try to really push Delaware cases into Delaware. I think the allergen decision here, it remains to be seen what that effect is going to be.
Rich, as Delaware practitioner, do you want to weigh in?
And I know we only have about 3 or 4 minutes, so let me just do it quickly. On the fundamental point of form selection clauses, it is likely their enforceability will differ whether you put it in the charter versus the bylaws, because a board can create bylaws and therefore it's not enforceable. And I think there's at least one California opinion refusing to enforce a bylaw selection. Facebook has a charter provision. And in New York, the New York judge did not enforce it, but it was fact specific very recently. And it was because of the timing when the issue arose versus the certificate being filed that included the forum selection clause. And based on the facts, the issue arose before the charter was filed. So you have two cases out there that are non-Delaware, one saying bylaws won't be enforced, one that could be read as charters won't be enforced, but when you dig into it, it's actually a factually distinct set of circumstances, but it doesn't address the enforceability of the charter itself. And I think Strine's opinion is likely going to be the first substantive opinion on that particular issue, and that's the most interesting, I think, at this point of what's going to happen next.
Before we conclude, there's been a lot of topics and a lot of law we've discussed today in a fairly short period of time. See if there are any questions from anybody, either in the room or online. Yes, sir.
Say on pay disclosure situation, you get a demand letter from, this may or may not be based upon actual facts. You receive a demand letter from a shareholder, and you look at the client's say on pay disclosure, and you go, you know what? It's a close call as to whether they dotted all their I's and crossed their T's, but we're just going to amend the disclosure because we can, and we're going to put a little more in there. And do you do that, or do you wait to be sued and move to dismiss? Because in the situation where you revise, the plaintiff's counsel can come in and make a fee application, as I understand it, to say, hey, we did something for you, you now need to pay us. Whereas if you waited and got it dismissed, then there wouldn't be a claim for fees.
Well, I mean, it's a close call. I mean, the plaintiff's bar, by all signs, invested a lot of energy in this theory. Q4 last year, Q1 this year, hasn't really been putting as much into it recently. So there's a little bit of a gamble. You could supplement, take away their theory if they're paying attention, which they may not be anymore. I mean, all these suits, I forgot to mention, all these suits have been filed by essentially one law firm. You're rolling the dice, but you might skate by. If they file suit, the trend is clear that they have been dismissed. But they could find some forum where nobody's ever heard of this and get an injunction.
And on the fee point, it seems to me that if it is injunction to force a disclosure about something that is purely advisory, when you go to actually calculate out what the fee might be, how do you articulate the benefit that went to the stockholders? So it may be that even if you ran that path, the number might be so low that it's still ultimately the safer path.
Right. You really circle back to where we started today in terms of the disclosure-only settlements.
Okay, I would like to thank everybody for joining us today. I'd like to especially thank the panel and Rich for coming up from Delaware this morning to join us. If you have any questions, either those in the room or online, just shoot any of us an email. We'd be happy to respond and continue the dialogue. So with that, we'll conclude the session, and thank you all very, very much.
Which are filed in Delaware only. What happens to these cases? So we'll talk a little bit. About settlement trends. Of these cases, looking at the last 3 or 4 years, 60 to 70% of the cases filed in any given year have settled. The rest of the cases, between 5 and 10%, have been dismissed on preliminary motion, relatively low percentage. About 25 to 35% have been voluntarily dismissed, which can signify a bunch of things. One is that the plaintiffs have given up based on some preliminary ruling from the court, or they've decided to proceed in other fora or bringing other types of claims. Of the settlements, and the first substantive topic we're going to talk about is disclosure-only settlements, some recent case law. Of the settlements that have been reached, approximately 80% of settlements are disclosure-only settlements, meaning that what shareholders get is expanded supplemental disclosures and nothing else. No kick in stock price, no negotiation of appraisal parameters, no reductions in deal termination fees, just better, more disclosure.
And the question as to whether it's better disclosure is one we can certainly debate. It's clearly more disclosure, usually a little bit some more cash flow information, or some kind of more evaluative information, especially in the real estate context. So a little more language is thrown in, and then the proxy goes out in final form.
Fair enough. James, you were going to talk about.
But that's the question of whether.
Good morning. My name is Scott Schreiber, and I'll introduce the panel in a second. I'd like to introduce my co-panelists for this presentation on Delaware corporate litigation. As corporate markets rebound, what you need to know about litigation risks. With me are my partners John Friedman, who has worked in this area for a number of years, litigating cases in Delaware and elsewhere involving breaches of fiduciary duty asserted by plaintiffs, as well as securities issues and accounting issues. And also with me is my partner James Thomas, who also has been around this country litigating breach of fiduciary duty cases, securities cases, and accounting cases, and dealing with the SEC on such issues as well. And we are also very honored to have with us today Rich Rollo of Richards, Layton and Finger in Delaware. And as we all know, Rich is without a doubt one of the leading practitioners in this practice area in the country. And probably he and his firm have more experience than just about any other firm in this country in dealing with these issues and really being on the cutting edge of litigation and advice with respect to M&A fiduciary duties, and we work closely with them, and it is always an honor to do so. Thanks, Rich. Appreciate you joining us. What we want to cover today are a number of subjects that have been the focus of litigation lately in Delaware, and as we will discuss in other jurisdictions as well. First, we'll talk about Delaware corporate litigation trends and settlement trends. John will talk about those. We'll discuss issues.
The additional disclosures, meaningful disclosure, is an issue that the Delaware chancellors and vice chancellors have taken up recently in a couple of cases. The concern, obviously, with disclosure-only settlements is given that the shareholders aren't receiving any meaningful economic interest in the settlement. The merger price is not being adjusted. It's really an adjustment to the informational right with respect to the proxy. The concern that the Delaware court has is whether this is really a question of the first filed plaintiff's firm selling their claims to take a fee rather than benefiting the shareholders in any meaningful respect. Very recently, Chancellor Strine, in somewhat surprising but consistent with what we'll discuss later, sort of a trend toward concern over this notion of a race to the courthouse and first filing in the transatlantic case, rejected an agreed upon settlement. So it's a situation where the plaintiffs and defendants had agreed to a settlement, had agreed on a cap to the fees. Obviously, defendants, the typical entrance is to escape the litigation. Sort of these merger cases are really just a merger premium to get.
With respect to settlement, namely the disclosure-only settlement, and what the courts in Delaware have been doing with plaintiffs' application for fees in those situations. We'll then talk about recent cases on fiduciary duty. First, in the M&A context, there are a couple of major decisions describing the director's fiduciary duties in the M&A context. We'll talk a little more broadly about some developments in the fiduciary duty with respect to Caremark claims, and with respect to some other types of litigation that have come up where you've had a director suing to enforce a director's rights as a director of a company against other directors. We'll talk about the specific situation involving directors of companies with substantial foreign operations. And then we'll turn to some specific M&A tools that have been the subject of litigation, namely the don't ask, don't wait provisions that you've heard so much about and read about. And finally, we will talk about some of the current litigation involving say on pay and the proxy litigation, as well as issues surrounding multi-district litigation, where we have actions being brought not only in Delaware but in other jurisdictions, and how the courts are dealing with those and which actions will go first and will proceed. So with that, by way of introduction, let me turn it over to John Friedman, who will talk about trends in litigation.
Thanks, Scott. I just want to set the stage a little bit why we're here and why we're talking about these issues. And I'm going to just give, before we get into discussion of some of the case law and important trends, talk about statistics and what happens when these cases are filed, what the disposition, where these cases are filed, and what the disposition of these cases are. I'm going to quote some numbers, and all these are out of the relatively recent analysis done by our friends at Cornerstone Research, who put out their periodic survey, last periodic survey in February. So in 2012, looking at mergers and acquisitions where public companies are being acquired, for those public companies that had market cap above $100 million, 93% of those transactions were challenged in shareholder litigation. And if you look at even a bigger market cap, $500 million market cap, 96% of those transactions were challenged in shareholder litigation. Shareholder litigation is filed almost instantaneously. Cornerstone found that frequently the announcement of an investigation was announced within hours of the merger announcement, and typically first complaints are filed within about 2 weeks. The average transaction is challenged by 5 lawsuits. That means you've got 5 different firms competing to be appointed counsel and 5 different plaintiffs competing to be appointed lead plaintiff. The litigation is increasingly multi-jurisdictional. Of the suits that were filed or the transactions that were filed involving Delaware incorporated corporations, about 2/3 involved suits in both Delaware and in other jurisdictions. I think you might get some sense as to why, from comments in the rest of the session, why plaintiffs and litigants might be trying to avoid Delaware litigation. About 20% of cases filed in 2012 involving Delaware corporations